Hi, everyone. Welcome to episode 178 of the Immigration Lawyers Podcast. We're doing our regular monthly session with Kevin Gregg, immigration attorney. Oh no, partnership name is Kurzban, Zelli, and Gonzalez? No,
Pratt.
Pratt. Okay. Pratt. Well, I got Tetzelli, so we're getting there.
Yeah.
We're going to jump into it in a second, but as a reminder, first of all, the Immigration Lawyers Toolbox magazine is out. Please check it out at www.immigrationlawyerstoolbox.com/magazine. A lot of colleagues put a lot of time and work into this, and I think it's a great thing to have a trade magazine. The first issue is out. Please check it out. And I want to thank you, our sponsors, in particular, DocketWise, the immigration form and management software for immigration lawyers. If you go to www.doctorwise.com/immigration-lawyers-podcast, you can get an extra 10% off your annual plan, which I strongly recommend doing. It's a great software program that's constantly being made better and adjusting to what users need. They're very receptive to getting what you need done. They're a great crew of people there. One of the co-founders is a fellow immigration lawyer. You catch our interviews that we had in the library for the Immigration Lawyers Toolbox. So with that, I want to bring in Kevin. Kevin, how you doing?
I'm doing great. It's kind of, I'm honored. I've been speaking a lot recently. I think it's because of the podcast a little bit. I don't know why else anyone else would want to talk to me.
You don't invite me. I don't know. I like this immigration. No one invites me, but
well, it's the AILA South Florida conference was last week. It's a pretty big conference, and with Zoom, it makes it eligible to talk from across the country. And so I was doing that, and no, it's been good, and the podcast has been good too. So like I'm talking every week to somebody. I don't know who's listening, but
yeah, you do a tough job because you're doing deep analysis every week on Immigration Review, your podcast. So that's, I mean, you have full weekends just focusing on that.
Yeah, that's, I try to read the decisions throughout the week after the workday is over to then get my outlines in as best I can. I refine them on the weekend, and then some of that tech and that recording on the weekend. It's definitely a lot, but also I think I'd be a much worse lawyer if I wasn't reading them anyway myself. So the extra step of recording and talking with everyone, it's not so much.
You read these cases on your own, and many people do, but to go the extra mile of being able to explain it again to other people and redo the information, I guess that's when you know the knowledge the best, when you could teach people about it. But that's a lot of extra work. But at the same time, you'll catch stuff and it'll stay with you a lot longer by doing that way.
Yeah, and I hope it's helpful. I think I have something to help the bar. That's a high bar because there's a lot of smart immigration lawyers out there. A lot of people doing this longer than me. So I hope it's helpful. And I like hearing feedback. I like hearing it is. I haven't heard negative feedback yet. So if you've got it, let Kevin C. Gregg know it in LA. If you've got negative feedback, let Kevin C. Gregg know it. And if it's good feedback, let Kevin A. Gregg know it. And happy to hear it.
The quantity of pieces of information that come out when you're an immigration lawyer is just overwhelming. You could be great at what you do, but just a number of these circuit court cases, USCIS policy changes, ICE updates, it's just overwhelming to be able to handle it all.
Yeah, I have the benefit of being partners with Ira Kurzban and being in that firm, and he's doing all of it all day long. So I have the benefit. I don't really touch the regs or the changes. Like I leave that to Ira. He'll send out emails sometimes, and then there's the whole everybody else sending out stuff. So I'm focusing on the case law, which of course Ira does as well. I don't know how he does it all, but at least I have that advantage. I'm happy that I'm with a firm that we can work off one another as well. It's not just all me.
Mm-hmm. So thanks for coming on. We're doing our regular session about federal court updates for immigration purposes. How many cases do you have this month?
Well, I've got about like 6, but I'm not going to go too deep into any of them. And they're all in the asylum type context. Although before we get to all of those, because I know you're more of an employment guy, John, this week, last week, and so it'll drop tomorrow on the Immigration Review podcast, the First Circuit in the case of Oliviera v. Wilkinson addressed when an I-140 petition, or actually when a cert petition, when a labor cert is approvable when filed such that the individual is eligible for 245I adjustment. Mm-hmm. So that's a bit employment, and it's pretty good. And the First Circuit in that case makes the point that the board and the USCIS should not hold it against a non-citizen that they don't have an employer relationship to prove that a labor cert is legit, because you can't have an employer relationship until the labor cert is approved.
Yeah.
And so I thought that was a good distinction. But I also bring it up because, as with all 245I labor cert cases, it discusses my favorite BIA case of all time, matter of but. And so that was a lot of fun to talk about on the podcast because I'm a child. So tune in if you want to hear me talk about matter of but. So that's the employment decision I have.
It's because they sent him back and they questioned how the immigration judge at BIA reviewed it and the extra mile they went to read it in the most negative fashion against the. And so I was very satisfied to see they sent him back on that one. Because the 245I, for those who don't know, it's the people who want to adjust status in the U.S. If they had a case started for them, it could include labor certificate, which is interesting. In the 90s or up till there's a cutoff date.
April 30th, 2001.
And so it should be an open and shut case. I mean, if they filed it and it wasn't bogus, it should be fine, But I'm glad whoever the applicants were and their lawyers fought it till the end, because a lot of people would give up. You say, okay, you go past the BIA, what's it going to do? So happy that they pushed all the way to the circuit court to push them back and say, this is pretty. The way you're analyzing it's not correct. So I was happy about that.
Yeah, it seems that some shady stuff went down in that case. I mean, the attorney, for example, who filed the labor cert got disbarred, and it was with that attorney's own employment company, non-law company. And the First Circuit says that Mr. Oliveira was trying to take advantage of 245I as he saw it winding down. Nothing necessarily wrong with that, but it does seem that what the board and the IJ were really doing is they didn't believe Mr. Oliveira was legitimate with his labor cert, and so they were not going to give him the benefit of the doubt in any of that, because sometimes bad facts make bad law.
Yeah,
I suppose it doesn't make it necessarily right, but I guess we're all human.
Well, I just read the synopsis, so I didn't realize those were the facts. So it's good to go.
Okay. Yeah, that's no, I'm not defending anyone. I mean, the decision is what it is, but
I see where they're coming at now. Whether
right.
I thought they were just being unnecessarily strict on it.
Yeah, but it's good too. And they said you have to analyze the labor cert by the law in effect at the time. You have to go back to Department of Labor standards from 2001 in this case, because it was filed in 2001. You can't just look at everything and say, I don't think it's meritorious. That's not what matter of but allows. So interesting case there. And I start off with that today because the rest of what I've been looking at is asylum, because there were some just bombs of asylum cases over the last month.
Well, let's do it.
The first was Amaya v. Wilkinson. Oh, they call it Amaya v. Rosen. I guess it should be Amaya v. Wilkinson, out of the Fourth Circuit at the end of January. And a lot of people were talking about this because in this case, Judge Quattlebaum in the Fourth Circuit, who's actually a Trump appointee, refused to grant Chevron deference to matter of WGR, which is one of the two seminal particular social group cases. The companion one is matter of MEVG from 2013 or 2014. And so the Fourth Circuit, I believe it's the only circuit, is now not deferring to matter of WGR, which really dealt with the particularity requirement for a particular social group. There's, immutability, particularity, social distinction. That's what these cases are saying. Those three elements are required for a particular social group. But in Amaya, the Fourth Circuit is saying what the BIA did in matter of WGR, it's impermissibly blending social distinction and particularity. And that's because really the terms are very confusing. But in essence, in this case, the Fourth is saying to meet particularity, you don't look at the country conditions at all. You just have to have a lawyer who writes out the social group with limiting boundaries. And so that certainly makes it a lot easier when doing a particular social group analysis. And it really puts the entire argument into social distinction. That's when you have to look into the country. That's when you have to look into the country conditions and really see how that society views your particular social group. But according to the First Circuit, it's not how you do particularity. It's not deferring to matter of WGR. And more importantly, former Salvadoran MS-13 members is a particular social group in the Fourth Circuit after this decision. So that's a big deal.
Oh, that's incredible. Fourth Circuit, Virginia, North Carolina, South Carolina, Maryland. That's a major district to have this kind of decisions covered.
Yeah, and it's, I don't like to label who the judges are who are making these decisions, who appointed them, but it's nice to see a Trump appointee doing that to really show that, the law is the law, and you can't pin a judge necessarily by who appointed the judge.
Immigration, yeah, you never know what you're going to get with immigration.
That same week, and I guess I'll go through them a bit quick because, got a lot. Just in the headlines, Kaur v. Wilkinson from the Ninth Circuit from that same week. This one was published on January 29th. And this one is just making very clear that rape is persecution and torture. Nothing really surprising there. But that attempted rape, just attempted rape, is per se persecution. And according to the judge, according to the Kaur panel, rape is one of these, quote, extreme types of persecutions that even an attempt is necessarily going to be persecution in and of itself. Mm-hmm. They also pointed to murder and kidnapping as other types of persecutions that even an attempt is going to be it. And so to me, the necessary question is, what else is in this group of extreme persecutions that apparently seems to be a thing, at least in the Ninth Circuit, that's such that even an attempt, I mean, creative legal arguments could abound. So far we got murder, rape, and kidnapping. What else will be a per se persecution when it's just an attempt? Mm-hmm. Also interesting from Kaur, it involves the country of India, and the individuals who were persecuting Miss Kaur were actually from a minority party. So to say that they were actually the government doing it is a bit difficult, because they weren't even the controlling political party. But the court is saying that when you've got these parliamentary governments, like most of the world is, where even minority parties can have significant influence, especially when it comes to local politics, then even minority parties equate to the government. So I thought that was very interesting, and that's an argument that many attorneys make, but I'm not sure if there was a case that you could actually cite to until Kaur to say that, yes, minority parties in parliamentary democracies, that's the government.
Yeah, very interesting. I mean, India is a big one that would apply to. I don't know, Israel has a parliamentary system. It's far between, but I mean, it's a great resource to have to cite that kind of case on a night.
Yeah, I think America's very unique, actually, in us not having a society that we do have a two-party system where the minority party is pretty much out of office. So, no, it was good to see. Kaur case, it's good for a lot of reasons. Cool. When I come on this podcast, go on your podcast, I'm really talking about the wins for non-citizens, right? Throughout the month, for every win, there's like 4 losses. But, when I come here, it's all gravy, right? Next, there's some interesting particularly serious crime cases out of the Eighth Circuit, which is not known as the most non-citizen friendly of the circuits, but back-to-back wins on particularly serious crimes. And of course, particularly serious crimes or serious non-political crimes, very similar to a particularly serious crime, will bar a non-citizen from asylum, potentially withholding, even if they have been persecuted or fear persecution. In Barahona v. Wilkinson, published by the 8th on February 3rd, they found, in essence, that a red notice, an Interpol Red Notice, standing alone, does not constitute serious reasons to believe that an individual has committed a serious non-political crime. That's because red notices are just not reliable. They don't. The Department of Justice itself, it says that they don't equate to probable cause.
Let's talk about that, because a lot of lawyers don't know about these red notices and how they could be. The lawyers involved with that invited them to come on the show, but they couldn't make it, so they might be doing an article on these red notices. But essentially, Interpol, countries could tell Interpol that this person did a crime, and there's a notice out so that local police departments around the world could potentially get them or detain them. But they're not really supposed to be. And in the Code of Federal Regulation, I think is like these aren't official things that you can be bound by, but because governments, especially tyrannical governments around the world, misuse and abuse those.
Yeah.
But ICE uses them still to come and pick you up and detain you, and you have to fight it out sometimes in immigration court. It get really nasty with these red notices, and it's hard to know if someone's on the red notice. If you have clients overseas who have any legal issues, you really want to ask them to kind of double check or look into that, because it could come up at adjustment of status where there's a red notice, and you'll have ICE officers waiting behind the door to pick you up.
Oh, the red notices get so nasty, and you have to be prepared. And there are entities, big law firms usually, that can try to get a red notice canceled, but it's a whole process. It costs a lot of money, and there are countries like Venezuela, Russia, that just are known to abuse the red notice process. The BIA issued a decision last year pretty much saying that a red notice is reliable, although they didn't go as far as saying that it could be the only evidence. But they also dropped a footnote saying that unless you can show that the country abuses it. So that's that whole argument, and that's going to be, you're not going to win that out. You're not going to win the day before USCIS with that. But maybe you'll get it in immigration court. You can get them out on bond. But yeah, they get really nasty, and it's kind of a way for sometimes countries to try to get these individuals back to their country when they know they can't meet the extradition provisions. They don't want to go through that. That's the real process, is extradition. You want your national back, your citizen back, try to extradite. But this is like the second lower way they use it. Mm-hmm. And when, serious non-political crime, which is what the Barahona case is, that doesn't require a conviction. So, and the non-citizen kind of has the burden. The non-citizen always has the burden to show that they are admissible. But in Barahona, the court is saying that DHS has an initial burden to show that one or more of the bars apply. And based on this decision, it's looking like that a red notice standing alone is not going to cut it. Maybe a red notice plus the foreign conviction document, the foreign charge. I don't know. But just a red notice, according to the Eighth Circuit, not going to cut it. And so that's a good decision to know.
Yeah, this came up last year in a case, and I didn't want to file for adjustment. They went with another attorney because I wouldn't file it because they had some sort of argument business-wise at home country, and they couldn't show up to court because they're in the United States, and they got essentially an absentia order for what the other side was accusing of, like check fraud or something like that, and they weren't there to defend themselves. They weren't even aware of it till afterward. And I said, get a lawyer in the home country to close that case up, then we'll contact Interpol. I don't want to put you in front of, USCIS with this out there. They might come pick you up, and who knows when they'll get you out. It's not you don't want to be in ICE detention, so like worst place to be. But another lawyer said, no, we can file it. It's fine. I'm not sure what happened with it, but that's something to be careful of, because it comes, even private parties could try to mess with you, and local courts and stuff will really make a life havoc for an applicant.
I'll say this with the in absentia convictions that you see so often with non-citizens, because they're in America and they often don't even know about it. We've made this argument in federal court. It's won the day twice. I think it's on all fours. I've never seen an actual case, a published case, say it, and that is this: at least in order to be an aggravated felony, 101A43 does allow for an in absentia foreign conviction to be an aggravated felony, or a foreign conviction, actually, to be an aggravated felony. But only if the term of imprisonment, the sentence has ended within the last 15 years, which is very weird that that's what the statute says. So if you get an in absentia conviction, and right, this is not legal advice, right? That's what the bar is saying right now. That's why I was trying to qualify it. But if you get an in absentia conviction and you've never been in prison, then necessarily you don't meet 101A43, because it had to have been less than 15 years since that term of imprisonment was completed. So if it never begins, it can never complete. That argument has succeeded before in court, and I don't really know what the counter argument is. So while this is not legal advice, it's something to look into at 101A43.
Just another complicated thing immigration lawyers have to be know about that. I remember it popped up for me. I was like, oh, wow, there's this whole red notice thing now. But it's good that they're fighting back on this. And a couple of lawyers who were on that case are working really hard, just focusing on that whole issue with Interpol. People.
We're part of a federal lawsuit in the Southern District of Florida right now with with Prada Olazar and ACLU of South Florida with a red notice case as well. We'll see what happens there.
We'll keep us posted.
And sticking with the 8th, honestly, I'm even more excited about this one. It's called Shazi v. Wilkinson. First of all, just for Mr. Shazi seems to have some issues, but he got those issues because he was working in Iraq for the U.S. government, figuring out what Saddam Hussein's biological weapons program was like, and it seems like he saw some pretty bad death. I don't know, maybe with the Kurds, and got some really bad PTSD, depression, and anxiety as a result. He was brought over before the second Iraq war, maybe the first, I can't remember, as a refugee, got a green card, but then he was convicted of some crimes. And again, seems pretty clear from the decision that it was connected to his PTSD. It's just really sad all around. Now, in 2014, I believe, the BIA issued a decision called Matter of GGS. So let me step back. Mr. Shazi applied for asylum and withholding again in immigration court. In 2014, the board decided Matter of GGS, which in essence says that an immigration judge cannot consider the mental health problems of a non-citizen when making the particularly serious crime analysis. The theory goes that the mental health stuff is considered at the time of conviction and sentencing, and an immigration judge is just supposed to say, you were convicted of this crime. Now, is this crime in the abstract particularly serious or not? That's what Matter of GGS essentially says. The Ninth Circuit overturned and vacated Matter of GGS. Like, as I see it, Matter of GGS doesn't exist. There's nothing for any other court to defer to. To my knowledge, the board has never reissued Matter of GGS in another circuit and said it applies to every circuit besides the Ninth. It's different than not deferring. It doesn't exist. But either way, the Eighth Circuit analyzed the case, in this case, Shazi v. Wilkinson. I'm not sure. Maybe I'm wrong. Maybe the Eighth Circuit is wrong. But either way, they analyzed Matter of GGS. And they refused to defer to it because they thought that it was unreasonable. Mm-hmm. So the Eighth Circuit is saying, no. You can and you should consider the mental health of a non-citizen when making the particularly serious crime analysis. So even if we're going to say that Matter of GGS is still something that an IJ can rely upon, the only two circuits to have analyzed it, the Ninth and the Eighth, are having none of it. So I thought that was interesting for a variety of reasons. And good for Mr. Shazi. I mean, not condoning criminal activity, but people deserve a second, third chance, especially if it's because of PTSD as a result of doing the U.S. government's work in Iraq.
Mm-hmm. Very interesting.
And after that, I've actually just got two decisions from the Second Circuit, and they're not even the decisions in chief. They are Judge Pooler, who is dissenting in both, because Judge Pooler is just going really hard on these cases in dissent. In these two cases, that one was 2 weeks ago and the other one is this upcoming episode of the Immigration Review. The first is Gallina v. Wilkinson, published by the Second on February 12th. In that case, it's actually about whether or not solitary confinement in Italy is torture. Mr. Gallina appears to be a mafioso in Italy, and he was in this notorious prison in Italy for mafia individuals. He spent years and years in solitary confinement, not so dissimilar to what the United States does with some of our prisoners. And in dissent, Judge Pooler is saying these quotes that, quoting Justice Kennedy, quote, "Prolonged solitary confinement is one of the true horrors of the modern day penal system," end quote. I mean, that's Justice Kennedy. And saying that there's not a single study in which solitary confinement for more than 10 days failed to result in negative psychological effects. So, some really good quotes to challenge solitary confinement, even though it didn't win the day in Gallina v. Wilkinson. Honestly, that might have been because it was Italy and a mafia member, maybe a different country. Some of these quotes would really help, and maybe it would help in Bond too. I'm not aware when immigration non-citizens are put in solitary so much, but maybe they are. And if they are, here's some great quotes about why that is truly Horrendous.
Mhm.
And then Judge Pooler in dissent as well in a case that I'll discuss tomorrow on the podcast called Zelaya-Moreno v. Wilkinson. In this case, her dissent is really, this is about an individual who refused to join a gang in El Salvador, probably MS-13. In fact, it's very clear it's MS-13. I only hedge because they only referred to it as MS in the decision. And he was saying that he refused to join because he had an anti-gang political opinion. And the majority is saying that's not a political opinion. Whatever. A lot going on there. But Judge Pooler in dissent, I read the whole paragraph on the podcast. I'm not going to do it here, but what she said is apparently former President Trump, I don't know if you remember him, apparently in 2018 went on TV surrounded by Bill Barr and other Department of Justice officials and had some press conference about how terrible MS-13 is and said that Nancy Pelosi supports MS-13, right? And like she's a bad person. Like, of course, Nancy Pelosi doesn't support MS-13, but like he's up there doing his Donald Trump thing. And Judge Pooler is saying, look, the president, the head of the executive branch, surrounded by the Department of Justice, got on TV and said that their opposition to MS-13 was political opinion as compared to their political opponent. But when Mr. Zelaya-Moreno actually opposes MS-13 in the home country of MS-13, that same Department of Justice is saying that it's not a political opinion. So I thought that was a very persuasive and an interesting analogy that I will be using in any gang recruitment case that comes across my desk. So that's all I've got. Terrible for Mr. Zelaya-Moreno. I don't want to make light of his situation, but I really do enjoy Judge Pooler's dissent there.
Very interesting, very neat. So how are things going with work and everything for you?
It's good. You know, we're blessed. We're really busy. Just a lot going on at all times. We are thinking of filing a lawsuit against EOIR for their new procedures in court that it seems to require the filing of a relief application before the Department of Homeland Security even establishes alienage or removability, which violates the regulations and, quite frankly, just due process. So if anyone's listening and they're interested in that and they have something to say about that, if they've gotten one of these scheduling orders, shoot me an email.
Beginning, send me a write up and I'll mention that in the next podcast at the beginning.
Right. Well, you know, things it's day by day, and we're doing the best we can. You know, there's only so many hours in a day, and you want to have some other life that's not immigration either. But it kind of just seeps into all aspects of it. Work is good. Work is busy. How about you?
Same here. I mean, the magazine is really time consuming, and the business has been good. So trying to like do both at the same time, it's been hard. I definitely need a staff up to help with the outfit. And the magazine, I just love doing it. And so instead of being monthly, I'm going to do seasonal because it's just too much work. So I have a whole magazine staff, and it makes enough money to support having, you know, being a full-on publisher. But it's a blessing, and it's been so wonderful. We've been able to connect with so many lawyers and so many young, either new lawyers or existing lawyers have emailed me saying how helpful the information was. So when something works, it's really satisfying. Over 2,000 people read it. Average read times 4 minutes. So they're actually sitting there reading the thing. Know that. So that's it's been a hit. So I'm really happy.
It's really cool. I've got so much to say. First of all, I should have done at the beginning. Congratulations for this. We haven't talked since you published that. It is an amazing thing. I read some of it and I skimmed all of it, and it looks really professional, really well done. So congratulations for that, John. It's awesome. I must say that and you've done it before, when you start talking about like young lawyers and guidance for young lawyers, I look at us. I'm like, are we old? Or I don't think so. I mean, can we distinguish between young? I hope not. But I mean, then again, we've been at it for almost a decade. In my case, maybe a little more. I also do find it amusing. I don't know, what did you intend when you did the magazine? Because you've published once and you've said, screw it, I'm going seasonal. Or did you intend that from the get-go?
So I realized, I thought, if other lawyers are submitting the articles, how much work it'll be. Other people are sending articles. It's like, no, there's like a million and one things you have to do. And the practice takes a lot of time and just, putting out. So I'm going to do seasonal and then have special issues that focus. So I'm going to have a 01 only issue between spring and summer. That's going to be like hopefully 20 or 30 articles. I'm trying to get more lawyers to write specific articles on different aspects of the 01 visa. So it's going to be like nothing like it really out there. And so I'm prepping issue 2 and 3 at the same time. And as soon as 2 is out, we got to get ready for 4 and 5. So it's going to be a lot of work, but especially
that's a full-time job.
Yeah,
you just described a full-time job.
Yeah. I thought I could, scale it and get away from that, and wouldn't be, but it's going to be, which I wouldn't mind doing. I really enjoy it. So the viewership is there. Just got to get work on sponsors to justify the cost of it with the time I'm spending. But I'm really having fun with it. So it's definitely going to, go for a couple issues at least and then see how it goes.
Well, if the offer still stands, I'll get you something.
Please.
Not on the 01 issue. That's not my specialty, but someone at the Kurzban firm does.
Yeah. That'll be appreciated. And that, California has been sunny. I feel bad for the people in Texas and East Coast have been having a terrible time. How's Florida? How your partners doing in Florida with the weather?
Well, they're fine. It's all good. And I'm in San Diego, but they, my buddy actually flew in from Manhattan last weekend, and he was here for like 3 hours. He's like, I'm coming in 18 months. This is absurd. I'm done with the Northeast. But no, we are lucky out here.
Yeah, it's a good situation. It's a little windy here in LA, which gets my allergies up and running, which has made me sleep a little hard. My nose running and stuff from the allergies. But overall, it's been pretty good.
Well, it's good, and I'm always happy to talk to you. I stuck on the asylum cases this week because there were some interesting ones, and I found on the podcast that having now read every decision that's been published since mid-April 2020, it's probably like 60% asylum cases, right? Those are the ones that usually get up there, and so you want to try and keep the asylum cases interesting. I try to go through the ones where there's not really anything to offer. I try to go through them quicker, and because I recognize that a lot of immigration attorneys don't do asylum at all. But stuff like that red notice, the inadmissibility, that's applicable to everybody. But it's hard, right? Like if you've got a red notice, you've got this helpful 8th Circuit decision that says you shouldn't just rely on the red notice. But are you really going to put your client before a consulate officer? Are you really going to bring your client into a USCIS office with a red notice? You got to roll the dice, and you can make legal arguments for days, as you know, with USCIS, and they might just say, tell it to a judge in 6 years.
Yeah. It's horrible. Or like you have to go through a bond hearing or something like that.
Go in detention for a month and a half.
And you get COVID in there. Who knows what kind of craziness, they get beat up or something. When you get asylum a year afterwards, you can file for adjustment of status. Typically, there was a colleague who posted in a Facebook group that at adjustment of status, they said, you have to submit, I think, a 602 waiver because you had a overstay or something like that. And so it's not typical that USCIS would request that, but they did in this case. And I just wanted to put a note out there. I don't think people are really supposed to do that because once you get asylum, all this stuff's forgiven. But you never know what you're going to get with USCIS.
No, right. No, there is a special waiver for like the I-730, which is comparable to, I guess, similar to adjusting through asylum. But I'm surprised that they'd have to waive unlawful presence. But I guess if there was another bar to admissibility, I could see a USCIS officer doing that. But
I guess they can, but they don't usually enforce it because I've seen these cases. We just submit the adjustment, nothing happens. But it's just every day is different.
Every day is different. You just don't know what you're going to get.
The thing that's bothering the most, because they're having more and more consultations on this, is the policy that President Trump's administration put in late November for naturalization, where they said if you're out for more than a year, or you abandoned by being out too long, even if CBP lets you back in, the CBP determination doesn't stand. And when you file for naturalization, even if outside the 5-year period, they should NTA you. Not they should, and for abandonment. And so I'm having these consultations with people. They're like, yeah, 2009, 2010, we were out for a year and a half, 2 years. I'm like, I don't really want to file this right now because I don't want you to get an NTA for something happened 10 years ago.
It's terrifying. It's Stephen Miller's weaponization of USCIS. That's just what happened. And the law is the law, but there's so much discretion in between what's black letter law and how you apply that law. And obviously, I'm preaching to the choir. Anyone listening, no, they just weaponized everything with the most harshest, narrowest, non-humane way of interpreting all this possible, and it would have gotten so much worse if they had done it again.
They were just on every day we're getting stuff back at the end of the administration, but we have these landmines that are still there. So anyone from the Biden administration listening, please update the USCIS policy manual on this one. This is just a quick fix. This is not shouldn't be happening. Stuff like this.
Yeah, I don't envy them though. I mean, even Stephen Miller, all those guys, they knew what to do. It still took them like 4 years. Jeff Sessions didn't release matter of AB until 2018. Mm-hmm. Even for the people who are laser focused on destroying immigration, it took them a while.
Yeah.
So I'm worried. I'm not the only. Everyone's saying like, give Biden time. It's only been a month, and there's so much other things to do. It's a lot. There's a lot that needs to happen.
And who knows, next administration, if it goes that way, it could all come back again. So this takes 4 years. I mean, Congress has to act and put some statutory stuff that makes sense. I mean, yeah, we've talked about this many times. Who knows what's going to happen with that?
I'm just looking at myself in this gray in my beard. I don't know what else is happening. I don't know if I can do another.
That's immigration. Fresh blood, new lawyers coming in, because before you do this, it's like full contact football or something like that. You get hit mentally constantly through our clients and through the case law and all this stuff. It really wears you down, but it's satisfying because you really change people's lives. So there's a special energy that you get from doing it.
Absolutely.
Good stuff, Kevin. Thanks so much for coming on again. I'll be seeing you next month, and definitely everybody catch the Immigration Review podcast. There's excellent analysis. I've had people email me telling me how much they love Immigration Review, how great it is. So definitely it's something to be on your list every week. You should be listening to it, because if you're practicing on anything that's, really anything, I'm only pretty much focused on adjustment of status, marriage cases where I don't need waivers, but I still need to hear this stuff out. And that's why I have you here. It's a personal
matter of fact.
Exactly.
You're not immune. They hit your subject area too recently.
Oh, yeah. It's always something. So it's really good to have you on to help the audience out. Thanks again, Kevin.
Thank you, John, and congrats again on the publication.
I appreciate it. I'll talk to you next month.
Bye.
Bye.
Am I still live?